Good afternoon, and welcome to the Effective Advocacy in the U.S. District Courts for the Northern District of Illinois Settlement Assistance Program. My name is Kenyon Gordon. I'd like to thank our four sponsors, the Federal Bar Association, Seventh Circuit Bar Association's Committee on Pro Bono and Public Service, Chicago Lawyers Committee for Civil Rights, and the U.S. District Court. I want to acknowledge the Chief Judge of the U.S. District Court for the Northern District of Illinois, Honorable Rebecca Pallmeyer. Judge Pallmeyer, would you like to say some words?
Yes, I'd like to welcome all of you to the program this afternoon and to say thank you for the work that you are doing and that you're about to do on behalf of us as you work with unrepresented individuals and helping them to resolve their disputes. The work of the court involves many activities, but the most important thing that we do is to bring repose. And as you know, settlement is really the best way to dispose of cases and to bring repose. It brings finality, it brings a sense of closure for people. It's very much a case that it's enforceable, and it provides people with a way of moving past their disputes and moving on to what we hope will be a better chapter of their lives. You, when you work with us in these settlement efforts, are arms of the court. You're the face of the court to people. You represent justice to the individuals that you have been willing to take on and serve. As you know, not all cases that we have in our court require recruitment of counsel. What is very much helpful to us, though, is in cases where there may be some problem that has evolved, some matter that involves money, sometimes matters that simply involve a rearrangement of priorities among people. Having lawyers to help document that is extremely useful to us. The skills that you bring when you deal with opposing counsel and when you deal with an individual that you're representing are skills that those individuals don't have and from which they very much benefit. As Chief Judge, I certainly didn't expect to be dealing with the circumstances that we're all dealing with right now. Presenting this program by way of video works well, but of course it's very much more pleasant to be in the courtroom with you. And a year from now, I'm hoping that that's what will happen. In the meantime, though, we've all learned new ways of representing individuals, of dealing with individuals, of meeting with individuals. And I know that some of those things will be talked about in this seminar this afternoon. But the most important thing is that you understand we in the court very much appreciate your efforts. We don't say thank you enough. Sometimes your efforts are almost completely unrecognized. But I want you to know that we judges know what an important contribution you're making. And we are very grateful for everything that you're doing. We're also especially grateful to Kenyon Gordon. She's been part of this program for quite some time. She has been kind of an inspiration for all of us, and she's a backstop when lawyers are not available to take something on and help resolve it herself. I want to thank you, Kenyon, and thank everybody that's on this faculty for what you're about to convey. Best wishes to all of you. I'm looking forward to seeing you in court. Thank you.
Thank you, Judge Pallmeyer. I want to give you an idea of what you can expect this afternoon in today's program. The first thing that you'll learn is the what and the why of the Settlement Assistance Program. The second presenter will talk about what we call Tales from the Front. She's a former SAP volunteer, and she'll talk about her experience in that role. After that, we'll hear about how you can improve your client communication by listening differently. And last but certainly not least, we will have a moderated judicial panel sharing best and worst practices for settlement conferences. So let me start with what is the Settlement Assistance Program. First of all, its formal title is Pro Se Litigants Settlement Assistance Program of the U.S. District Court for the Northern District of Illinois. Through this program, the court recruits members of the bar of the district court from the private bar to represent pro se litigants who have brought civil rights cases in the court. Now, this program has been in existence since 2006 and has represented hundreds of pro se litigants and helped them navigate the judicial system in a way that they could not have without the assistance of volunteer counsel. So it's all in the name, pro se litigants, settlement assistance. So why are these litigants pro se? You might say that it's because they have losing cases, but that's not the case. They are mostly indigent. They are mostly people of color. They have been aggrieved by either the correctional system or by the employment system, and they cannot afford or find counsel. And that means some of them cannot afford the retainer that counsel want up front. Some of them have relief that they're seeking that is too small to warrant the time and attention of members of say the employment bar or the bar of specialists in prisoner civil rights. And they've asked the court to provide counsel. Now, the court could provide counsel for trial, but the court also decided that since most cases settle anyway, they should provide representation solely for the purpose of settling the case. So what types of cases do these pro se litigants bring? They're primarily civil rights cases, and that includes prisoner civil rights cases, so that people who are incarcerated in the Illinois Department of Corrections or in county departments of corrections can bring their cases that involve their conditions of confinement, their right to safety, or their lack of medical treatment. That is for people who are in the state and county systems only. We don't deal with federal prisoners. The second big category of cases that are brought by these pro se litigants is employment discrimination cases. The statutory bases of race, sex, age, disability are all represented in the cases that these litigants bring. There is the occasional outlier. For instance, sometimes the person who needs representation for settlement is actually not the plaintiff, but a defendant, say in an ERISA case where a pension fund has brought a case against a pensioner. I have one of those available if you're interested, and where they allege that, say, they have paid too much to the pensioner and they're looking for a recovery. So why settlement and not representation for trial? As I said, most cases settle in the district court, but settlement sometimes gets a bad rap, especially by hardcore litigators who think jury trials are the be-all and end-all. Actually, settlement has its own virtues. For one, it can turn the parties from adversaries to cooperative. I don't mean that you stop representing your client zealously, just means that if the parties are trying to reach a common goal that's satisfactory to both sides, they find that they can be more cooperative than adversarial. Settlement is compact. In the time that it takes to be appointed to a client and the time you go to settlement conference, it can be as little as 8 weeks to 12 weeks, which is much more compact than your typical litigation. In settlement, the parties control the outcome. The client decides whether she will accept a settlement or not. So it's completely within the client's control, which is something you don't have in a jury trial. In settlement, parties are able to control the costs, no depositions and discovery disputes and dispositive motions. All of that gets compressed and costs are controlled. Another virtue is confidentiality. You can keep the result confidential, and the process of negotiation is confidential anyway. So the parties can benefit from having that confidentiality. Another virtue is creativity. Now, the lawyer in a settlement can fashion relief that might not be available under the statute that the case is brought under. Maybe some relief that a jury or judge could not give. For instance, with a prisoner, the relief might be that the prisoner wants to be relocated. And if that's within the power of the defendant, then you can use your creativity to reach a form of relief that would otherwise not be available. And as Judge Pallmeyer said, closure is an advantage. Parties want the pain to be over. They have often lived with the circumstances that caused the litigation in the first place, and they lived through it alone. And closure allows them to move on and get on with their lives with perhaps some monetary or other relief that allows them to get things going. So why do we have this program? For one, it increases access to justice for everybody, regardless of income or circumstances or social status. It gives members of the bar a chance to satisfy their pro bono obligations. And that's whether the obligation is a personal moral one for you or it's one imposed by your employer. As Judge Pallmeyer said, it also aids the court. And there is nothing like the gratitude of a federal judge to make you feel better at the end of the day. Our representation of these pro se litigants takes a lot of the pressure off of the court in having to shepherd an unknowledgeable person through the system. And in the end, access to justice for all enhances respect for the court. The community sees the court not as a place for the wealthy and powerful, but a place for everyone where everyone can get respect. So how does this work? The litigant files a lawsuit in the district court, usually on a form that is provided by the court. Prisoners file on a form that actually has the statutes under which they are bringing the case. It has and asks for simply a clear statement of what is wrong, what happened that requires relief. The court, if the court decides that this is an appropriate case for settlement, a case to take off of the litigation track and save time and money and effort, then the court will put in the record that it requests settlement assistance program counsel for the litigant who needs the assistance. The case goes to the SAP director, that's me, and from me, it goes to a pool of volunteers, which you'll become a part of at the end of the day, and you assist the client, so it kind of goes full circle where it started with, which is with the client and with helping this pro se litigant find relief in the court. So what does the SAP director do with this case that comes from the district court? The district court sends over the bare information, who the parties are, what stage the case is at, and that the party needs representation. So I review all of the pleadings. I review the complaint, the answer, any salient motions. I then call or write the litigant. I do that so that I can find out if the litigant still wants to settle. And I also do it to fill in some of the blanks. As I said, the litigants file these complaints, sometimes in handwriting, sometimes typed, but often on just very bare bones. Something bad happened to me. I think that was wrong. I want help. And so I contact them so that I can fill in the blanks, so that I can tell you, the potential volunteer, exactly what to expect with the case and to get you to take a case. So I prepare a written summary, and when I have one or more of these, I send them out in email to a pool of volunteers. Right now I have about 300 volunteers, but I'm hoping to have another couple hundred at the end of the day. and I contact you. I facilitate the appointment by the judge, and then I assist the volunteers if they have questions as the case proceeds. I follow up with help with, say, strategy, or with developing an appropriate settlement amount, or developing a relief plan, or sometimes with managing the client, but that's rare. So I'm showing you right now a sample opportunity. In fact, it's an opportunity I have available right now. It's Timothy Hall, who's an inmate in Pinckneyville Correctional Center, claims that when he was at Stateville Correctional Center, the conditions of his confinement were unconstitutional. And so he has gone through the administrative process that's required of prisoners, and he has now brought a case against the warden, alleging that the warden was indifferent to the circumstances of his confinement. Now, Judge Harjani has the case for the settlement conference, and I send this out. If you are interested in a case like this, you would contact me and let me know that, and we can proceed with getting you appointed to represent Timothy Hall. Now, if you have questions, you can use your drop-down menu that's on your control panel to ask questions, and I'll answer them at the end. So the question you're asking yourself now is, why on earth would I do this? For one, as I said, you satisfy your pro bono obligations. That can be those that you hold. You think that providing pro bono services to the community is a good thing to do, and so you do it. And sometimes your employer has an hourly target that the employer wants the members of the firm to meet. The second is that it feels good to help someone who is not as well off as yourself and doesn't have the skills that you paid so many thousands of dollars to get. I am not only the director of the program, I'm a volunteer. I have taken over the 10 years a dozen or so of these cases, and I can vouch that it feels good to help people. I told you already that it assists the court, and you know how good that is. For some of you younger attorneys who are doing document review or preparing interrogatories and document requests, it gives you client contact. You get a client of your own for whom you are responsible and whom you can assist, and you talk to, and you strategize with, and you develop a settlement plan with. Another reason you might want to do this is a quality federal court experience. You do have to write a settlement demand in this process, and that goes to a federal district judge who might see that you're an excellent written advocate, and there's always advantage to that. And you get to spend 2 or 3 hours in the morning or afternoon with this federal judge and the settlement conference itself, which is with you, the judge, the opposing party, and the opposing party's counsel. And the special perks from the program are 2. One, if you are not a member of the trial bar and you take this training and you take a case from the SAP, you can get 1 simulation credit toward membership in the trial bar. And if you are a member of the trial bar, you can, and you get called up for potential appointment, you can take 2 SAP cases and defer being called up for trial in that cycle. Now, you don't need to be a litigator to do this. Transactional attorneys also have the skill set needed to negotiate, to strategize, to analyze a case. So you need not be a litigator, although most of the volunteers are. So don't let that transactional practice stand in your way. So the volunteer, as I said, contacts the director and says, I'm interested in that case with Timothy Hall. I want to run a conflict check in my firm to make sure I don't have a conflict of interest that would prevent me from zealous representation. If you're a junior person, you might need to get a supervisor. Then the judge would assign you to represent that litigant. You file a limited appearance, just like in the same electronic manner that you would file an appearance in a trial case, and you proceed to represent your client. Now you contact your client. Some attorneys want a retainer agreement, and some use that and others do not. The litigant has already acknowledged the limitations of the program, that the person is representing them only for the purpose of settlement and not for trial. And they've acknowledged that to the judge, they acknowledge it to me, and they sign a form to that effect, that I understand that this person is helping me with settlement. If the case does not settle, the volunteer simply asks to be relieved, and the volunteer has no more responsibility. So what exactly are the duties? Now, the duties that I've outlined here are the same duties that I tell the client that you have, so that your expectations and the client's expectations mesh. I tell the client that you will confer with her, that you will evaluate the case and advise her of the strengths and the weaknesses of the case. Sometimes the litigants don't know the weaknesses of their case, or they can't see the weaknesses, they can only see the strengths. That's one of the important roles that you provide, is that you give them a reality check. You discuss the damages that are permitted by law. Some clients know that and some don't. Sometimes the clients believe that their case is worth a lot more than is actually the viable settlement amount. You write a demand for specific relief and you have a rationale. So that document looks like maybe a mini brief. You set out the facts of the case. You say, this is why my client is entitled to relief, and this is why my client wants this particular amount. You serve that on the opposing counsel and you give a copy of it to the court. You negotiate with opposing counsel. You can have offline negotiations between the lawyers involving the clients or not involving the clients. It's obviously informing the clients, but you can negotiate with the opposing counsel, and occasionally the case is settled without going to the settlement conference. But if it isn't, you'll represent the client at the settlement conference, that is with the judge and the opposing counsel. If the case settles, you are responsible for finalizing the settlement documents, that is the written agreement, and you're responsible for seeing that it's carried out. Sometimes if the settlement agreement calls for money, you want to make sure that that money is actually paid to the client, and you want to make sure that the settlement documents don't contain anything that you did not agree to. So you have to be meticulous at that point where your client might not understand that. What do you not have to do? You do not have to amend the complaint. In fact, you cannot amend the complaint. That means that you get what you get. The complaint you get is the complaint you live with, and it's not always as great as you would want it to be. And sometimes the cause of action that the client has chosen is not exactly precise for the facts that you develop, but you're stuck with that complaint or amended complaint or whatever. You don't have to take and defend depositions. You do not engage in endless motion practice, and you do not have to do discovery, no formal discovery. Of course, you can get discovery from the other side sufficient to develop a settlement strategy, obviously. So if it's a prisoner, you may want that prisoner's health record or discipline record. And if it's an employment case, you may want that person's work history or attendance records or something. And the parties can negotiate that and get that information informally, so there's no formal discovery. Now, you might get the case when some discovery has already been done, but you might also get it when there's very little discovery already done. So you're developing the facts and the strategy without all of the formal discovery that you might have gotten and that you might have had to wrangle about for months at a time. So I said that you contact your client and you confer with your client. If your client is in one of the correctional institutions, be that the county jail or an institution of the Illinois Department of Corrections, you can communicate with them in writing and by telephone. And since we're in the new times, you can communicate with your client outside of the incarceration context by video. And in the case of a prisoner, the settlement conference itself is held on video. And in fact, all of the cases right now are being held on video. They're virtual, but I haven't done one myself, but I'm told that they are quite effective and efficient, and many cases have been settled on Zoom or on Teams or whatever platform you use. My last comment is that the key to all of this is respect. You may be the first person to give that litigant some respect. They often come from marginalized parts of society where respect has not been flowing their way. And in your case, you may be the first person to provide them that respect. I encourage you to be free with that and to zealously represent the litigants in the pro se litigants settlement assistance program. That is all for me. I am leaving my email address on the materials that you have that in the handouts. You can contact me about the cases I currently have. I have 3 or 4 that are available that need settlement counsel. And I want to introduce our next speaker, Allie Schaller. Allie is a former SAP volunteer. She's a commercial litigation associate at the law firm Loeb & Loeb LLP. Last year, she was identified as one of the ones to watch by Counsel Magazine. So let's watch her now, Allie Schaller.
Thank you for that introduction, Kunyan. Appreciate it. So hi, everyone. As Kunyan said, my name is Allie Schaller, and I'm an associate at Loeb & Loeb. And before I get started, I want to thank Kunyan and also Laura McNally for inviting me here today to participate in this program. And also special thanks to Laura, who without her guidance and mentorship throughout my experience at the SAP, I'm not sure we would have reached as successful an outcome as I think we did. So thank you, Laura. So before I get started, I also want to say this is a great program for all the reasons Kunyan said. Now you get to give back, and I think I'm confident I'm not speaking just for myself when I say, I got into the legal practice to help people fundamentally, and this is a great way to do it. You also get great in-court experience, which is what I'm going to talk about today. My experience as an SAP volunteer assigned to represent a pro se litigant in her settlement conference. Specifically, I'm going to talk about 3 things. First, I'm going to talk about the facts of the case to give you all some context and maybe a bit of a preview for the kind of case you might get if you end up getting assigned a case. I'll also talk about my experience preparing the client for settlement, the conference itself, and 2 approaches in particular that I think really set us up for a productive conference. And then lastly, I'll talk about a few of the applicable ethical rules that come into play in this kind of representation. And hopefully we'll have some time for questions at the end. If you want to send questions while I'm talking, you can do that through the chat box that Kunyan mentioned, and hopefully I'll be able to get to some at the end. So on to the facts. I was assigned a 1983 case that stemmed from an incident on a Metro train platform back in 2013. my client, Regia Whitney, was on her way home, and it was late, like 11 o'clock at night, on her way home on a weekday, waiting on the Metro platform at like 11 o'clock at night. She gets on the train, and as soon as she sits down, she realized it's not going in the right direction. She got on the wrong train, probably. And it wasn't her usual line, so she wasn't sure. So she asked a conductor for help. The conductor confirmed that what she suspected, she did get on the wrong train. So she got off at the next stop at his suggestion and waited for the next one, which he said should be there in 15 or so minutes. She ended up waiting a lot longer than she thought she would, about an hour, until the next train showed up. So the next train rolls up, and it actually was the same train that she had just gotten off of an hour earlier. It had just reversed route at the end of it. So the train pulls up, she gets on board and sees the same conductor, and she's upset at this point. She's trying to get home, and now it's about midnight, and she's trying to get home to her kids, and it's been a long day, all of that. So she asked the conductor, hey, you kind of gave me not so helpful advice here. And in response, he said something to the effect of, well, if you could read. And she was offended at that, and she wanted to report him. And at this point, the facts were in dispute on this, but they got into some kind of argument. She wanted the client or the customer service number or a supervisor number, something like that. He wasn't giving it up. And so she followed him to the vestibule where they continued arguing, so kind of towards the doors of the train. And it wasn't very long, this argument or dispute, whatever it was, because as she's walking into the vestibule, the train is actually pulling up to the next station. And when it walks up, the train doors open, and there are two Metro police officers there waiting, it seems. So the two officers, they board the train. They ask Ms. Whitney to sit down. She doesn't. So then they pull her off the train because she wouldn't comply with the order to sit. So at this point, they're back on the platform, or they're on the platform. And as soon as they pull her off the train doors close and the train pulls away. And again, it's late at night, she's trying to get home. And I'll also note here that from this point on, almost everything I'm about to say is on camera because the Metro platforms are surveilled. So there's a video of what comes next, although no audio. So they get off the train, there's the two officers and my client, Ms. Whitney, and they're yelling at each other. Again, you can't hear it, but you can see from their gesturing and their expressions, they're upset and they're arguing. And now what happens after this is it happens much faster than I'll be able to tell it. But Ms. Whitney, during this argument, she eventually takes a step back, and one of the officers then steps towards her and points in her face, but doesn't make contact. Ms. Whitney points back, also doesn't make contact, but as she points, the officer kind of swats her hand away, and then Ms. Whitney's other hand kind of goes up reflexively. Reacting to that, the officer, using an open palm strike, strikes Ms. Whitney on the side of the head. As she's doing that, the other officer goes around to the back of Ms. Whitney and picks her up. And you can see her feet leave the ground in the video. And then after that, they put her on the ground, and you can't see this part of the video, or there's no video surveillance of this next part, but they restrain her, she's on the ground, they handcuffed her, and at that point they take her away. And as they are leaving the frame, you can see, and I failed to mention this earlier, but Ms. Whitney is a practicing Muslim, and she was wearing a hijab at the time, and it had fallen off in this altercation, and one of the officers stepped on it on the way out, and Ms. Whitney saw that. That was part of it. Another detail is Ms. Whitney, when she was picked up off the ground, part of the reason that happened, and she's probably like 5'2" at the most, and both of the officers were at least a head taller than her, pushing 6 feet. So after she's handcuffed, she's taken to a holding facility where she's eventually released after several hours, and she was eventually charged with disorderly conduct and battery. But those charges were later dropped. It's not entirely clear what the disposition was, but they were seemingly dropped. So after all of that, Ms. Whitney actually did hire a lawyer. She was represented at the outset of this and filed a complaint alleging the 1983 civil rights violations. And then at some point in that early stage, she ended up, the lawyer withdrew, or they had a falling out, and she's then continued on representing herself. And there was some limited discovery, but not a lot, just a couple of deaths, including Ms. Whitney's death. So after that very limited discovery, Metro ended up filing for summary judgment, but several of the claims survived, even though Ms. Whitney was representing herself pro se. So the claims that survived included a excessive force claim, a failure to intervene claim, and then malicious prosecution for one of the claims I mentioned earlier, the battery claim against Ms. Whitney, because she never actually made contact, and then also a battery claim. So all of those survived, and in the summary judgment opinion, the court encouraged the parties to consider settlement, and that's about where I came in. So as Kanyana talked about, I went through the process, I heard about the case, contacted her, and then was appointed. So now I'm going to talk about working with the client and what that was like, and some of the approaches that I use that I think really set us up for success in the settlement conference to come. So obviously the facts of each case are going to be different. The procedural posture of each case is going to be different. I'm not sure that mine was so unusual, but I don't know that it's common that cases make it all the way through summary judgment with a pro se litigant. In any event, all of those things will be different depending on your case. You're going to have to familiarize yourselves with the facts. So my starting place after Kanyan's summary, I read the summary judgment opinion, which detailed everything I just talked about, and also an additional detail that was not briefed apparently, but the court raised on its own, the issue of qualified immunity. So we have had complicated and kind of traumatic facts, as well as kind of thorny legal issues, because qualified immunity is relatively complex. Even as a lawyer, it's not the easiest, certainly pro se, it's complicated. So there was a lot to learn. But one of the most important things was hearing this all from the client. I could only learn so much from the record, and I needed to develop a relationship with her in order for us to have a productive settlement conference. So I had two goals when I was, or many goals, I should say, really, but two that I'm going to talk about today that were, I think, the most impactful on the client and my ability to have a productive and ultimately successful settlement conference. And I'll note too that I think, although I'm happy to say we were able to reach a resolution that the client was happy with, I do think it's possible to have a successful settlement conference that doesn't end in resolution. I mean, if you can't compromise and meet somewhere in the middle, then that's that, and that's the client's decision, and that can be okay too. But you obviously want to equip yourself to be as productive as possible and to empower your client to be able to make those decisions in an informed and mindful way. So the two approaches that I really want to focus on are gaining the client's trust, as well as understanding really what it is that the client wants. So talking about gaining trust, as a starting point, when I first met the client, I really wanted to just hear her story from her, because I had read the summary judgment opinion and the facts were what they were, but I needed to hear it from her, and I wanted her to know that I wanted to know, because I think that that's really important to understand where they're coming from, because I think some of the story, and it may not matter from a litigation perspective, but certainly some of the story, the personal part of it, is lost in the pleadings, I think. So speaking with her was very important, and the first time we met, I wanted her to just tell her story, start to finish. I tried not to interrupt. I wanted to hear everything without any questions from me that might color the direction she was going. I just wanted, to hear her through and focus on listening, and we would have time to refine those discussions over time. But again, wanted her to know that I wanted to hear her whole story, and I was here to help her. Along those lines, I emphasized my role as the advocate. I was there to help, but at the end of the day, this is her case, and she makes the decisions, not me. And I obviously was very willing, and part of my job was to make sure that she had all of the tools to make those decisions. But I think that reminding her that she held the authority, this was her case, really helped develop that trust, which was then critical in being able to have the more difficult conversations that Kanyan referred to. And one other thing that I was very glad that I had talked to her about, and not just, assuming things from what the pleadings were, but having talked to her, I learned that she had had some previously pretty negative interactions and experiences with attorneys. So she was coming into this, I mean, to her credit, I do think she was very willing to work with me, and we got along and established a good rapport, but she did have this negative prior experience, and knowing that really helped me understand where she was coming from and why she was wary of the process, and all manner of things like that. So, really talking to your client and listening to them is very important, because you're going to learn things that will help you understand why it is they, made the decisions they made, and it's just very important so that they understand that you are listening to them too. I also tried to be as available as I could, and obviously one of the great benefits of this program is, as Kanyan said, it's compact, it's sort of limited and it's short, but I would encourage all of you, if you can, make yourselves as available as you can, because I think that really helped my client understand. It's sort of the old adage, there's no stupid questions. I wanted her to ask me anything and everything to feel comfortable, because you don't know in advance what the good questions are going to be. You don't know what's worrying them, and you want that communication line open, because if it's not open and you find yourself in the settlement conference, like Kanyan said, it's only a few hours long, and the interactions, the time that you have to discuss a new position with the client, it's not that long. I mean, you can take time and all of that, but having the established relationship of trust really helps facilitate a much more productive settlement conference, I think, because we could have quicker conversations where she knew what I was telling her, trusted what I was saying, and I also could trust where she was coming from. So I think that, again, trust is everything. I know Allison is going to talk about that too, but it's just hugely important. Obviously, you need to know the facts of your case and some of the law probably too. It's all going to depend, but knowing your client, that's always going to be true, and they need to trust you. So I really can't emphasize that enough. So the second focal point that I thought really helped us drive towards a successful settlement conference was really understanding what it is that the client wanted. And part of that, and this was an unexpected benefit, was kind of helping the client understand what she wanted. I think some of this was probably true for many of the clients. I mean, these experiences, a lot of them are traumatic. They're not necessarily just looking for monetary compensation. Maybe they want an apology. Maybe they want to make a statement to whoever it is that wronged them. Maybe they just want to be heard by sort of the neutral third party, the judge who's mediating your settlement conference. That can be kind of a good proxy for what is otherwise, being in trial and getting to tell your story. So all of those aspects of the settlement conference, I think, are really important to remind the client or tell them about, so that they can understand the full sort of menu of options that they may be able to tap into to have a successful resolution of the case. So you can get creative in this process, which is something Kanyan mentioned as well, in a way that you really can't at trial. You can also help the client understand the difficulties or the challenges of their case when you understand what they want, and help them manage their expectations. It's going to be harder to have a successful outcome if the client doesn't have a good sense of what's to come. And there are definitely built-in times in this process, like the settlement letter, the demand letter that the parties have to write. That's definitely a good jumping off point to have these more difficult conversations, because as Kanyan mentioned, sometimes, the amount of money that they think they should get out of this is not necessarily in line with, say, like similar cases that have had settlements approved by the court. And you can do that research to, show your client, well, here's what we typically see in similar cases, things like that. That's a good way to approach that challenge for sure. But again, these two, understanding what it is that the client wants and managing their expectations really went hand in hand with gaining that trust, because without having that trust, it would have been much more difficult to have these honest conversations about the challenges And some of the challenges won't just be facts, difficult facts that you might have to deal with, or difficult or thorny areas of law that might be difficult. There are also procedural challenges that the client may not realize are just ahead of them. And I know, depending on the case, certainly the procedural posture is going to be different. But in my case, if the settlement conference didn't resolve the matter, trial was the next step. So explaining from a place of authority what trial really meant, it's a long process. It's an exhausting process. Even when you know what you're doing, it's an exhausting process. And many of your clients will have full-time jobs or even part-time jobs that they will have to take time away from to represent themselves in trial. There will be evidentiary concerns that they may have, how to admit evidence, things like that, and just explaining sort of what that's going to entail, I think is very helpful, and it empowers the client to make a good decision and understand what it is that they're going towards if they decide, they don't want to settle. And certainly the uncertainty of trial is another a good reminder, because I think a lot of these clients are going to feel like, I know what happened to me, it was wrong, and what I just need to get up there and explain it, and the judge will understand. But at trial, nothing is certain, nothing is guaranteed, and they need to understand that, and who better to help them understand that than the lawyer assigned to represent them in the case. Another challenging area would be burdens of proof, and that's similar to the evidentiary concerns, but just explaining, what's to come if they don't settle. I really think that was important in managing the expectations. And also explaining that the settlement conference is such a great opportunity to avoid a lot of that and get that closure and just move on, which is probably something that a lot of these clients also want to do. I mean, in my client's case, this had happened 6 or 7 years before I ever met the client, but she still felt the pain of all of it. And I think that's important to remember in all of this as well. We are used to litigation and complaints, and we see it every day, but they're not lawyers, and they felt strongly enough about whatever happened to file a case in federal court on their own, or continued it on their own. And this is possibly the most important thing going on in their life. And I think remembering that very much helps that rapport that you really want with the client. So having done all this legwork, establishing that trusting relationship where you can have the honest conversations, and then having those honest conversations about what it is that the client wants, and managing the expectations of what is in the realm of possibility. Having done that work, you're going to be much better prepared for a successful settlement conference. Because if you don't do that, it could be much more difficult to have, the quicker conversations that you will need to have during the conference. So that's all very important. So as I mentioned, I am happy to say that we were able to reach a resolution during the settlement conference, and the experience entailed all of the professional experiences that Kanyan mentioned. You get counseling experience, you get negotiation experience, you're appearing before a federal judge, although a little bit different than what most of us litigators normally do, but still you're there in the courtroom, you're interacting with opposing counsel and the judge and your client, and it's dynamic and it's fun. So all of that is great professionally. And you also might get, as I did, a little bit of litigation experience after all. I ended up having the opportunity to, I ended up having the opportunity to argue a motion at the end of all of this, because we got in a little bit of a dispute about what exactly were the terms of the settlement agreement, even though we had gone through a term sheet. And I imagine the judges who all participate in this or mediate this, most of them, if not all, I would expect, have standing orders that will tell you about what they expect you to do to prepare for the conference. And one of them, I was before Judge Weissman, and His Honor had a term sheet that he wanted us to go through with our client in advance. So that term sheet was what drove the conference in large part. But anyway, We nevertheless found ourselves needing to file cross motions to enforce. So you might end up with a little extra litigation experience, even if you weren't quite expecting it. So now I'm just going to talk a little bit about some of the relevant ethical rules that are in play during these settlement conferences. So first, I'll talk about the scope of representation rule, Illinois Rule 1.2c. A lawyer may limit the scope of the representation if the limitation is reasonable under the circumstances and the client gives informed consent. So while you're the client's advocate, your representation is limited to the conference. And Cunningham went over that. You can continue the representation if you want to, but again, the default to the appointment is limited to the settlement conference here. And as Cunningham said, because of this limitation, the experience is quite manageable in a way that many other pro bono opportunities aren't. It's hard to slice and dice a case, and this is one of those areas where you kind of can. You just jump in just for the settlement conference. So it's a contained experience. The second rule I'll talk about is the communication rule, Rule 1.4. A lawyer shall promptly inform the client of any decision or circumstance with respect to which the client's informed consent is required by the rules, and shall reasonably consult with the client about the means by which the client's objectives are to be accomplished. And a lawyer shall explain a matter to the client to the extent reasonably necessary to permit the client to make an informed decision. And that kind of dovetails with the other rule I was going to mention here, informed consent, defined in Rule 1.0e, which is the agreement by a person to a proposed course of conduct after the lawyer has communicated adequate information and explanation about the material risks and reasonably available alternatives to the proposed course of conduct. So these two rules together speak to, I think, empowering the client to make her own decisions by giving her all of the relevant information that she needs to make that decision. And here I would recommend being mindful of making assumptions about somebody's knowledge base. I think that it can be easy sometimes to gloss over details that you assume the other person understands already. And in this context, you need to be extra careful and extra mindful that you are explaining things enough that the person can really make that informed decision. And they all kind of dovetail together. But the next one is the allocation of authority rule, Rule 1.2a. A lawyer shall abide by the client's decisions concerning the objectives of representation and shall consult with the client as to the means by which they are to be pursued. And a lawyer shall abide by a client's decision whether to settle a matter. So the bottom line here is the client drives the decisions. And as I mentioned, I found that the spirit of this rule really helped solidify the relationship between the client and I, because I think that reminding her of what my role was and what her role was really empowered her to take the information I was giving her and really think about it, but also be confident that I wasn't looking to undermine anything that she wanted to do. I was looking to help her and advocate for her as zealously as I could. And I think, again, this allocation of authority rule, just coming back to that rule with the client, can be really a nice tool to develop that relationship so that you can be productive and work together to have a productive settlement conference. One last rule I'll talk about here is truthfulness in statements to others. And this is Rule 4.1. In the course of representing a client, a lawyer shall not knowingly make a false statement of material fact or law to a third person, or fail to disclose a material fact when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client, unless disclosure is otherwise prohibited. So I'm happy to say I didn't personally encounter this rule, but this rule is, of course, maybe a fairly obvious one, but it can serve as sort of a shield for us in these representations. If you have a client that's maybe pushing you to bend, what the facts say, and this speaks a little bit to what Cunningham had said, was you play the hand you're dealt. Whatever the complaint says that's what you got. And this rule could come up a little bit there. Like if you have a pro se litigant who maybe meant to say something else and didn't pick the exact perfect claim that maybe they should have picked in moving or in filing their claims in federal court. You know, we're obviously constrained by these rules, and I think showing the client that we are bound by these rules could be helpful to you if you find yourself in a situation where you know, maybe they are pushing you to say, well, what I meant to say was this, and well, no, you know, we have to stick with what the complaint says, and here's this rule. So I think in a lot of ways, these rules not only can support the relationship that you develop with the client, but they can also serve as a little bit of a shield when you're in a little bit more of a difficult situation. That can help guide you as to what you should do, and also remind the client through another piece of authority, these rules, that we as lawyers are bound to these rules, and we're officers of the court, and that's part of our role. So that is all I have for you today. So I do have some time for questions. It looks like I only have one for now, and it's, do incarcerated clients have access to video conference equipment with the appropriate confidentiality? I think that's probably a question for Kanyan. I'm not sure. I would certainly hope that that's the case, but I can follow up with Kanyan after this program and answer that question and find out with certainty, and we can get back to you. So now I will turn it over to our next speaker, Allison Margolis. She is senior counsel at Sperling & Slater, where she litigates complex commercial disputes. She also serves as a mediator in commercial and employment matters and volunteers with the Center for Conflict Resolution to provide conflict resolution skills trainings for new mediators. And she's presenting here today on behalf of the Center for Conflict Resolution.
Thanks so much, Allie.
Yeah, thanks.
Hi, everyone. And thank you also to Kanyan for inviting me to participate here today. I'm really happy to be part of this training. As Allie said, my name is Allison Margolis. I'm senior counsel at Sperling & Slater. I'm a corporate litigator, and I'm also a mediator for commercial matters. I volunteer as a mediator, and I do trainings and coachings, sometimes as a volunteer for the Center for Conflict Resolution. I have for about 6 years. The Center for Conflict Resolution is a mediation center in Chicago. Since 1979, they've provided free mediations. CCR also provides trainings to law firms and to nonprofits in conflict resolution and in mediation. Today's training is one of my favorite topics. This will be useful, hopefully, with if you can volunteer for the Settlement Assistance Program and also maybe in your practice. These are skills that you can use, conversations with your clients, and I'll try to help you to be the best volunteer that you can be as part of this program. I'm going to share my screen with you now. There you go. So hopefully you can follow along. These materials are also available for download with the other materials for today's program. So today we'll talk about how to help you get behind the position that your client has taken, which will help you and your client to see new ways to think about the possibilities of settlement. And it starts with listening to what the person needs, which Allie talked about a lot. She apparently has not gone through this training, but I think you'll find that there's a lot of overlap with what she did and found really successful in her work with her client. So first, I just wanted to start with a story that I think illustrates a little bit about what can be helpful about listening to your client. One of my colleagues' kids his son had bet with his daughter over the Super Bowl, and his son was a big football fan, knew a lot about all the players, all the statistics, and had picked who he thought would win. The daughter was not a football fan, did not really know so much about the players or the stats, and just picked who she thought would win just for the heck of it. So the team that she picked won, of course, and it made the son crazy, and they had a big fight about who was going to pay. They had bet $5. And the son refused to pay up. He said, "You don't know anything about football. It's completely unfair. It's totally unjust. I'm not paying you." And she insisted, "I won. You owe me the $5. You're going to pay me." So they had a huge fight over this. And ultimately, they were able to resolve it. But the only way that the son was willing to pay was, he said, "I'll pay you, but only if you're going to pay me something." So the way they figured this out, he paid her $10 and she gave him $5 back. And they were both happy. And I love this story because, first of all, it shows that nobody but the parties involved in a dispute really can come up with a better solution than the people involved. because they know what they want and they know what matters. And he got to the heart of what mattered. But the question is really, why was that a good settlement for him? Maybe it was a good settlement for him because it addressed fairness to his mind. It addressed his pride. I should get something because I knew who was best here. And ultimately, what matters is that they both walked away happy. And it was a settlement that stuck. So my first goal today is going to be helping you see the difference between a position and what a party really needs or what their interests are. How to ask the right types of questions to get at that need and interest, so that you can get the information that your client might not even know they need to give you. They might not ever have been asked these questions. They might not really realize what you want to get at to help them get the best settlement. So it's your job to get that information. So I'll help you ask those questions, and I'll help you think about how to listen to their answers, the most effective way to listen that will make them feel heard and that will help you in coming up with possible solutions. And we'll also talk about reality testing, because doing the hard work of helping them understand the risks and rewards of their potential options is maybe one of the most important parts of your job in this program. So first, understanding needs and interests. So imagine a scenario between coworkers, Joe and Larissa. There's one orange left in the refrigerator. Let's assume this is post-COVID. And they both want it. So how do you resolve the dispute? You can split the orange, so maybe that's possibly fair because they each get half. Maybe one cuts and the other one chooses because that's a fair outcome. Maybe you flip a coin, so there's a process that's fair in resolving this. Maybe you decide who's more hungry, so there's a rights issue. It's a rights-based decision ultimately. Or maybe someone just makes the call from outside. An authoritarian comes in and says, neither of you get it. But if you ask why they need the orange, maybe you find out that Joe just won a trial and wants to make a mimosa, so he really wants the juice. And Larissa is baking that night, and so she really wants the rind. And so actually, they can split the orange where each gets 100% of what they want, and they're both really satisfied. So understanding why they need what they're asking for, what's behind their position, helps you come up with new solutions that are creative and that maybe no one would have thought of from the get-go. So if your client is actually really interested in safety or respect, then there's going to be a different way that you negotiate toward meeting that need. So we'll do a scenario here, a sample case. So your client is a 60-year-old clerk suing ABC Trucking for age discrimination. 8 months ago, he was given a new supervisor. Subsequently, the clerk was given an isolated office, poor access to the accounting system, and was told he was not aggressive enough in solving problems. The company says they fired the clerk for poor performance, but the clerk claims it was really because the new supervisor thought he was too old. So your client is demanding $100,000. If this case were sent for settlement discussion, how could you approach it? What's the client's position here? You can take some time to discuss with the client why that's his position, and it will help you get valuable information toward resolution. So what could some of his needs and interests be? So looking at the scenario, his workspace was moved. He was isolated. He had poor access to the accounting system. Maybe that was key to his job. You could ask, what was it like for him to have his job change like that? Or what was his job like before this change? How did it feel to do his job? And then what was the difference after it was changed? Maybe his job became harder to do. Maybe it was totally not feasible. And how did that feel for him, having worked there for X amount of time previously? You could ask about, what are his primary concerns at this time? Does he need medical coverage for his family now that he's been laid off? Does he need a good reference? Is he more concerned about his future employment? Why did he pick $100,000? What would the money mean? What does he need it for? What would it mean to wait for the money for 2 years if he had to go to trial? These are all important questions, and really any question that you're curious about when you're hearing your client's story is probably a good question. You should follow your curiosity. But I'm going to talk about ways to ask effective questions, ways to get at all that information. So who here has had a settlement that you thought was going to stick and it fell apart? Show of hands. So you need effective questions to get at the needs and interests, and getting at the needs and interests can help you get a settlement that will stick. So there's two types of questions. You're going to ask different types of questions to gather information and an understanding of the other person's viewpoint and underlying concerns. So the two types of questions that you might use to achieve that are closed and open. Closed questions ask questions narrowly, and they invite a limited and specific response, such as, how much do you want to settle this? What year did you move to Chicago? When did you start your job? Do you have any siblings? Closed questions, very narrow. Open questions are broader, and they invite a narrative answer, like, could you tell me about your background? If you ask, could you tell me about your background, the response can be about someone's family, their immigration experience, their education, their work background. Or what was your work like before this incident? Very broad. And then the person answering can choose how they want to answer. So if we're looking for needs and interests, open-ended questions are better. If you want to limit what someone's saying, maybe if they're rambling, or if you're filling out a form and you just want a specific piece of information, then you want a closed-ended question. If someone isn't giving you a lot of information, though, then you want to switch to a broader question. It invites a different kind of answer. So we'll take a few minutes to practice reframing a closed question into an open question. And normally when I do this presentation live, I would have you turn to your neighbor and I would challenge you to ask only one type of question and try and get a lot of information. But since we're doing this virtually, I'm going to ask you to look at the square that provides you the chat box through GoToMeetings or GoToWebinar. And I'm going to ask you to type into your chat box an answer, and then I'm going to read back some of the answers I'm getting. So I'm going to give you a closed question, and I'll ask you to reframe it to an open question in the chat box. So first question, and I'll pause and let you respond before I read the responses. Did you have a good day? So try to reframe that into an open question. How could you ask that question in an open way? Did you have a good day? So you want to look for your question box. For example, here's one, tell me about your day, or what was your day like? Okay, second. Did they give you feedback? Can you reframe the question? Go to your question box for attendees. Did they give you feedback? How could you ask that in an open way? So you could reframe it into, what was their response like? What are examples of responses? Okay, next. Do you have any relevant emails? How can you reframe, do you have any relevant emails? So one example, what kinds of records do you have of the communications you had with them? Or what evidence do you have? That would invite a very broad response, and it lets the person answer however they want. Next, would you be willing to testify? How can you reframe, would you be willing to testify? Okay, what are your thoughts about testifying? Or how would you feel about testifying? Okay, and last one. Is money the only thing you're looking for? How can you reframe, is money the only thing you're looking for, into a broader question, an open question? You could ask, what kinds of things could the defendant do to make this right for you? Or what would make this right for you? Not all questions should be open questions, of course. There's a time and a place for each. So I'm going to go over why you would choose open or closed questions to give you some sense of strengths and weaknesses of each and the right time to use them. So the impact of closed-ended questions. Closed-ended questions will get you specific information. They're centered around the person asking the questions, like in cross-examination, when you keep the focus on the person doing the cross. That's closed-ended. Those are all closed-ended questions. Closed-ended questions do not build rapport. There's no momentum. They can be awkward. It can feel a little bit like an interrogation or make a person defensive. Open-ended questions, though, give you a lot of information. They're centered around the person answering the questions. So the exact opposite, right? The person can answer however they want. So the focus is on the answering person rather than the questioner. Open-ended questions build rapport. They feel more natural. They're like a conversation. So they make people more comfortable. They create connection because they're like a conversation. Seem more sincere. So those are some reasons why you might choose one or the other. Now we'll talk about how you listen to the answers you get to those questions. The way that we listen is really important. It goes to what Allie talked about a lot, about building rapport and building trust. This is where it happens. So there's 3 ways that we can listen differently. There's active listening, summarization, and dealing with emotions. Dealing with emotions appropriately and in a productive way is really tough, and it might be people's least favorite part of what you're doing here for some people. So I'm going to talk about that a little bit too. So why? What's so important about how we listen? How we listen validates the speaker if we do it right. It can build trust. It can create possibilities for settlement, because once you have trust and rapport, then you can have the heavier conversations and the more difficult ones. And you can challenge, which at the end of this today, I'm going to talk about doing some reality testing and being able to challenge your client and have them hear it and be able to tolerate it. That's going to come out of what you've done for building trust. So active listening first. You probably know all of these skills, so I'll just quickly click through them just as a way of reminder. Using eye contact is really important in terms of your active listening skills. It's so hard, obviously, if you're doing this over video, but if you look into the camera, then your client will feel more like you're looking them in the eye, and it's the best that you can do. But eye contact can be really important for building trust. Face the person speaking, lean forward, show them that you're listening, like physically show them that you're listening helps. Restate what they say. This can seem awkward, I guess, and phony, but to restate back to the person what they're saying shows that you really did hear them, and it can be really helpful in making that clear and making that obvious. So you want to use that judiciously, but restating what the speaker's saying can be a really helpful tool. Ask relevant, open, non-judgmental questions. You might have to leave a lot of your judgments at the door for the purpose of the conversation, and just be really open and willing to hear what the person says without any judgment. It gives them a lot more confidence that you're listening to what they're saying. You want to acknowledge emotions. I'll talk more about that later, but acknowledging what you're hearing can be really helpful in showing that you are actually hearing it, especially if it's something tough, like a heavy emotion. Next is one of my favorite skills that I've learned from the Center for Conflict Resolution in terms of mediation skills training, summarizing. Summarizing has been a really effective tool that I've used a lot of times in mediation, and it can be really helpful with hearing a client story and letting them know that you've heard them. Similar to restating. Summarizing is going to be saying back what you have heard. It can be pulling together the threads of a long story or of lots of different facts that you've heard over time, or it can be just summarizing a set of facts in a scenario that you just heard all at once. But summarizing will be a really helpful tool. The benefits are that it's going to make the speaker feel heard and validated. It lets them know that you understand what they explain to you. It will keep you on track with their key points. So if it's a rambling story or if it's really disorganized thinking that you're hearing, you can be the one to organize all that information and summarize it back into a clear story. And that can be a really useful tool. It's also going to allow the speaker to make corrections or additions. Because if you say something wrong, and I've experienced this, they'll correct you. They'll say, no, that happened after the other thing, or that it wasn't she that said it, it was him that said it. And they'll clarify information for you. So it's a good way of double checking that you heard correctly and that you've got it right. Some tips. If you're hearing the same thing over and over again from your client, what they're saying is you don't understand or you're not hearing me. So repetition is a really important thing to listen for. It can be a sign of something that you've missed. It gives you an opportunity to address it too. I told you that the speaker will correct you if you get it wrong. Also, summarize early and often. Obviously, you don't want to be really repetitive about it, so you got to use your judgment there, but you don't have to wait till the very end to summarize every single thing that you've heard. Do it along the way. It shows that you're listening carefully and it lets you stay on track. So what might it sound like? It might sound like, when you summarize, what I hear you saying is you had privileges that you earned, and then those were taken away from you, and then you ended up in this more junior position that you never would have taken in the first place. Or it sounds like your responsibilities were cut back, and in the end, you had a totally different job. Or, so you said Jones threatened you, and then while you were eating lunch, you reported it to the CEO right away, and he said you should just be a man and take care of yourself. Did I miss anything? So if I were live, I would have you now turn to the person sitting next to you and practice summarizing in a conversation with your neighbor. Instead, I'm going to suggest try it with a friend or a family member in a conversation, just when they've told you about their day or about a road trip they took. Just practice summarizing. It'll be useful. Next, dealing with emotions. So like I said, this is a lot of people's least favorite part of this job. But exploring and acknowledging emotions can be a way to get at needs and interests. Maybe you've had a client in the past who demanded something that you thought was really unreasonable. So if you explore emotions, you can sort of understand where that's coming from and also help dissipate them and lower the temperature a little bit. So the way that you do this will be, we'll do two-pronged attack. Explore and acknowledge them. So exploring the emotion will involve asking open-ended questions, which now you're an expert at. If you ask the open-ended questions, you can just follow your curiosity and ask about how they felt. Ask about what was it like and see where they take you. And then you need to acknowledge the emotion. So you want to name it if you can. You want to show confidence in naming an emotion. It can be disarming to the other person, and it can also give them permission to name it and acknowledge it too. And that can be a really powerful tool. For example, it sounds like it was humiliating to have your responsibilities taken away from you. Or I hear you saying you were so anxious about your safety that you couldn't eat. That must have been really stressful. Just be brave enough to say the words and see what happens from that. If you can't name it, then you need to ask more questions because you don't have enough information yet. Some tips. Emotions are symptoms of unmet needs and interests. I'll say that again because that was a really useful lesson, to me anyway. Emotions are symptoms of unmet needs and interests. So if you're hearing a lot of emotion, then you know there are unmet needs and interests. And then you want to understand what those are. And again, if you don't understand what those are, you just keep asking questions until you do. And you can be really transparent about that too. You can say, I must be missing something. I see that you're so upset. I hear that you're still really angry about this, but there's something I'm missing, so I don't understand why. So tell me more about that. You also want to be open to discussion beyond the elements of the legal claim because the emotions that you're hearing might not be directly tied to the elements of the claim. But there's still something going on there, and it'll be helpful to you to understand why, because the best way to craft a settlement solution is to understand really what you're trying to address. And last, you can listen and acknowledge an emotion without having to agree with it. Obviously, you're not going to agree with everything that you hear, so you can just acknowledge something and just know that you don't have to be exactly in the same place as the person who's saying it. You want to stay away from, conversely, I understand, I would be upset too, or I know you're so angry. I understand why. It can be dismissive, and it can also make the person feel righteous. Again, the goal is to take the temperature down. So what you want to say is that you hear what they're saying, and tell me more about it if you need to hear more about it. And that's a way to de-escalate and to sort of it can be a way into understanding what you're hearing. So you can explore without getting into the weeds. You don't have to be their therapist, and you don't have to agree with everything that you're hearing. It may be, hopefully will be, a really positive experience for your client to feel acknowledged. This can be the time that, it might be the first time that they feel like they've really been heard or understand by someone involved in their case. So this can be a really powerful experience for them and feel a little bit like a day in court because they got to really be heard. So last, reality testing. This can be a really essential tool, as Ali said. Reality testing can be a very useful thing that you're doing for your client. They might not have had anyone push back on what their position is or what they're asking for in settlement. And so this can be an opportunity for you to really help them more than anybody else has. Again, when you come into reality testing, what the proposed settlement option may be, you want to suspend your own judgment and your own beliefs. Come in thinking you don't know the answer. That can be a hard thing to do, but come in open-minded. Another suggestion I would have too, when I've done this in person, I've actually done it on paper. So again, if you're doing this virtually, you might not be able to, or maybe it's something that you could show a screen. But to have things written down to visualize what we're about to talk through can be really helpful. And it's helped me a lot in, everyone learns a different way, and it may be that your client is more visual. And so seeing the answers to these questions can be a helpful tool that you might want to try. So reality testing is going to involve asking questions to help challenge your client's perspectives and their settlement options. And again, your goal is not to convince them or for you to be right. You just want to help them think through potential outcomes. That's what this is about. So some reality testing techniques that I'm going to run through. Best alternative to a negotiated agreement, which we call BATNA. The best alternative to settling this, and the worst alternative to a negotiated agreement, the WATNA. So the worst alternative to settling this. So helping your client talk through what their alternatives are if they don't settle, best and worst, can be really helpful and frame things in a way that they might never have done. You're going to ask, what happens if you don't settle here? If they don't accept what we ask for, or if we don't accept their counter? What's the alternative? Is it trial? I'd let them come up with the answer, but maybe they're going to say, well, it's trial. I'm going to go to trial. I'll totally win this. What will trial be like for you? How long do you think it will take? Are you able to take off all that time? Can you deal with the stress that's going to be involved with that? How stressful do you think it'll be? What's involved in your trial? What's our evidence? What's our best case? What's our worst case? There's always a chance we lose, right? The worst alternative too, likewise, take them through with multiple questions. Have them talk it all the way out so that they've thought it through. They might actually not have ever done that. What's the worst alternative? Maybe they get nothing. What will that feel like? And you want to check on the needs and interests that you've already elicited so that you understand, are they meeting those needs and interests? Have they expressed a really strong interest in closure? Is that one of their strongest values? Did they talk about needing relief soon? Can they afford to wait? How long does trial take? Go through all of those questions. The second is litigation analysis, which is probably something that you're all prepped to do anyway, and you already assume that you would be doing that. So obviously you're going to be talking through how strong the case is and how likely you are to succeed or not, and what that experience will be like. So I won't talk too much about that. Objective and industry standards is the next category. This one involves several different ways of comparing or drawing out what other people might have thought or might have said to your client. So help them think from different people's perspectives about this potential settlement that they're considering. So first, what would the average person think of this? Have you talked with anyone? Have you talked to your neighbor, your coworker, your friend, anyone else about this? What do they think about this option? It's, again, not about getting them to the right answer. It's about challenging their perspective and helping them see it a different way. They may never see it the way that you're seeing it, but you can help them think about what would someone else think of this. To step outside of themselves for a second. What would an expert say about this? The expert could be, a friend or family who's got a lot more experience maybe in this area. They may not know someone who you would consider an expert, but someone they consider knowledgeable. What did that person say? If they said this settlement option was terrible, well, how do you see this differently? And do you agree or not agree, or to what extent do you agree? Also ask them, what's your understanding? If the next category, law, rule, and policy. If there were a policy about this or a rule about this, which presumably by now you've talked about with them, how does this rule or this policy help or hurt? Do they make this a better settlement or a worse settlement? Or are there other options that this law or this policy shows us? What do you think about the current law or rule or policy and how it affects us? And then next, flip side. Flip side is thinking through a settlement option from the other side, from the defendant's side, so that we can be better prepared. And here you can say, you know them, this defendant better than I do. How do you think they're going to react to this? What do you think they think of this? What do you think their position is coming in, and why? What do you think they want to get out of this? That could be a frustrating series of questions for your client to be asked, but it could also be really helpful for them. They might not have really put themselves in the defendant's shoes yet. So that can be helpful to understand how strong their position is. And last, feasibility, durability, and fit. Feasibility is all about how likely is this settlement option to meet your needs and interests. This can be a really tangible exercise. Again, you can write it out on paper if that's helpful for them. But we've talked about your needs and interests, right? You have a whole set of those, understanding what your client really wants, really needs here. Is this potential settlement going to work? And durability is, will it last? Will it stick? What happens 2 weeks from now? What happens 2 months from now? What happens in a year? Does it really work? Does it really stick? Have you met all the needs and interests? And you can kind of tick through those. And if one of them is a need for closure, address that. Does this create closure for you? Great. Does this really meet your financial needs? And go through each of those. And fit is, does it work? Does it address each of those things that you need? And it's maybe not the perfect solution. It's compared to your BATNA and your WATNA. So checking feasibility, durability, and fit will help make sure that it's a settlement that really works for them. So the upshot is your client has needs and interests that underlay their position. Your goal is to try to find out what those are. You can do this by asking questions the right way and listening to the answers. You can do this by experimenting with different types of questions and listening differently to the answers. You can use active listening, summarizing, and dealing with emotions to help your client. And hopefully you can help them get what they need. So next we're going to hear from Laura McNally, who will be moderating our panel of distinguished judges. Laura McNally is a veteran SAP volunteer. She's a partner at Loeb & Loeb and serves as the program's chair and the secretary of the Seventh Circuit Bar Association. She also volunteers as a mediator with the Center for Conflict Resolution. Thanks, Laura.
Can't hear you, Laura. We can't hear you, Laura. We can't hear you.
Oh boy, I just said the funniest things already. You just gotta trust me on it. So thank you everyone for being here. I just did perfect 2021. I'm still on mute. Thank you, Kunyan, for putting this program together and for running the SAP program. It's such a real gem of our district. I'd like to introduce our judicial panel. We have District Judge Andrea Wood, and we have Magistrate Judge Jeffrey Cummings with us. I think we might be joined in a little bit by our third judge, but we're going to get started right now and hear from the judges about what works and what doesn't work in the settlement advocacy process. We're going, as you've heard today, that process doesn't start at the settlement conference. It starts way before, when you meet with your client, when you draft the demand letters and react to their offers at the settlement conference, and then there's the post-conference cleanup. And as you heard with Allie, sometimes that's where all the fireworks happen. So we're going to cover that whole timeline today. And I think let's just start then, if it's all right with you judges. I'd like to start with a little bit of talking about how do you find the cases that come into the SAP program? What do you look for? What are the qualifications?
Well, Judge Wood, would you like to begin, or I could start?
Either way, sure. I can go ahead. So obviously, I'm looking at cases where I have a pro se party. Almost always it's a pro se plaintiff in a case, though there have been situations where I have tapped into the program with respect to a pro se defendant. And in fact, a lot of times where there's a situation with a pro se defendant, either an individual or maybe a small company where it's just one person who owns it, sometimes I look at those cases as a good candidate for pro se assistance, because generally speaking, we don't tap into our trial bar pro bono program to assign counsel for the full litigation. In cases where we have pro se defendants or pro se corporate defendants, and of course, if there's a pro se corporate defendant, then they're going to be defaulted if they don't have counsel.
Right.
So sometimes I look at those cases and think there's an opportunity, if they just have an attorney to help talk them through it, to get a settlement. Much more common are the situations where there's a pro se plaintiff. I'm looking, one, to make sure that it's somebody that I think will work with the settlement process. I try not to tap into the resource if I think that the plaintiff is not really interested in settlement or willing or able to work effectively with a lawyer. And most often it's a situation where, for whatever reason, I think going to the settlement assistance program first prior to assigning full pro bono counsel for the full litigation is a better use of the resources. There could be a variety of reasons for that. But I think most importantly is trying to identify the cases with the pro se parties that would benefit most from an early settlement conference, and where the pro se is actually, willing and able to work effectively with an attorney through that process.
And I just want to welcome Judge Harjani to our panel. Thank you for joining us. We're talking in that pre-section. So that once you have an appointment, and Kunyan works her magic, and we have the volunteer meet up with the client, whether in person or remotely, these days entirely remotely. One of the first things that'll happen is the writing of a demand letter or an offer if you're on the defense side. So I think the magistrates tend to have standing orders when it comes to this process, but I'd love to hear from Judge Cummings. What do you encourage? What do you look for? What's your process with respect to those initial letters?
Well, good afternoon, everyone. In the initial letters, what I do is I want the plaintiff to do a number of different things. First, to lay out the facts of their case succinctly, the legal principles that they believe would entitle them to prevail, to provide a sense of what their damages are and all the different components of those damages, and then if feasible, provide some comparable cases that have either settled or perhaps gone to trial that support the settlement demand that's made by the plaintiff. I think in the SAP context, you're coming in with a person who's been representing him or herself throughout the course of the litigation, and it's important for you as their counsel to be empathetic, but not get caught up in their legal theory. They might be right about what the best theory is for them, but also they may, not having had legal training, they may not know what's best. And part of, I think, your duty is to look at the facts of their case and try to analyze it and put together the best presentation you can for them in that initial letter, because your initial letter will drive how the defendant or defendants respond. If it's something that's reasonable and it appears like there's actually a case there, you're going to get one reaction. If you get your client coming in asking for $5 million on a case that there's no possibility they would win $5 million, or not apt to take it seriously, and you're apt to get a response to your settlement letter that is similarly unreasonable from their perspective. So those are kind of the things I look for in the initial letter.
Judge Harjani, what do you find as the typical pitfalls or common pitfalls in the letter writing process?
Yeah, well, good afternoon, everyone, as well. Thank you for coming. In terms of pitfalls in the letters, I see places where at times I can tell that appointing counsel may not have had the hard conversation yet with the client. That is, the letter doesn't really reflect any of the risks in the case or acknowledgments of where there might be issues. And usually if you raise issues, you tell me how you're going to overcome them in terms of pieces of evidence or issues of law. But at least I recognize that you've thought about it, and you've likely talked to your client about it, because you generally have to get some degree of authority to send a letter to the other side. So I look for whether you've had that hard conversation, and I think that's a pitfall where I see statements by a lawyer that the case is a winner and there's really no chance that the defendant will win. That to me, is a signal that that conversation hasn't happened yet. And that often is, a predictor of things to come.
And when you say, what do you mean by predictor of things to come?
Meaning, I sort of predicted that the settlement conference might be more difficult, and it might be harder to reach a settlement if the lawyer isn't, being straight with the client as to the risks involved. I think, it is a balance. I think we all recognize that a new lawyer is to come in and win the trust of the client in a short period of time before, getting into a room with everybody. But at the same time, I think, a big pitfall along, as just Judge Cummings mentioned, with the outrageous demand of whatever it is, $1 million, $800,000 for a case that likely, might be worth in the, $10,000 to $30,000 range. That's a signal. And then I think not recognizing the risks in the case in the letters is also a signal that, the hard work hasn't been done yet.
Got it. Well, can you talk, and I'd love to hear from all three of you if you have any thoughts about kind of like the psychological side of the type of clients that we'll be dealing with in this settlement assistance process, like for the client counseling role of settlement conference. Settlement counsel. What kind of things are you seeing as kind of common? Are there any kind of common denominators or common themes in the clients that someone taking on these cases should kind of be aware of or open to or have their radar on for?
Mm-hmm.
Well, I guess I would just say that I don't think I've had any experience where a client without a lawyer has come in with an under estimate of the value of their case. It's typically over by quite a bit, and that's fine because they don't appreciate the law or the reality of the situation. But in terms of having that hard conversation that Judge Harjani is talking about, what's helpful is to point out why you're telling him it's too high. It could be in some, like with a Title VII case, for example, if there are damages caps. So if someone's working for an employer that has 30 people, there's only $50,000 that are available for compensatory and punitive damages, no matter how badly they've been damaged. So they could have a real horrific case, but there's a statutory cap. That's one example. Another thing is in prisoners' cases, and most of the ones I see are they're representing someone who's either had a case as a pretrial detainee or as someone who's actually been convicted of a crime and had some problem inside the penitentiary. There's a whole different set of considerations that go with that. But number one is the state or the county is simply not going to pay a boatload of money in settling one of these cases. That's a reality. And that's something that the client needs to hear before the settlement conference itself, so that they're not surprised if the county comes in with $500, or sometimes you might see $250. I've seen that, and that's what they think is a good offer, and from their perspective it is, but it could be stunning to someone that thinks they have a case. So you've got to give them a dose of the reality and what they're also going to hear from the judge before the conference itself, and even before the letter's drafted, so that it can be realistic. Sometimes you can end up with a better settlement if you start more reasonably than if you start at a really, really kind of unreasonably high level.
I think I would agree with everything that Judge Cummings said. I think part of having that difficult conversation is recognizing that I think the vast majority of the pro se litigants that I have come through my courtroom have actually had something pretty bad happen to them, something that they're upset about. Certainly the ones that I would assign settlement assistance counsel to, or recommend that the magistrate judge assign it to, that these are not the ones that I think are just completely, it's a fanciful claim, or they're just, trying to extort money from a party. These are usually people who legitimately feel that they have been wronged, sometimes in a very serious way. The issue is oftentimes people who have very bad things happen to them just don't have relief in federal court that they can get to address that. And it's sometimes difficult for pro se litigants, people who aren't as familiar with the justice system, to understand how it is that something really bad could happen to them and they still don't have a case in federal court. And especially in civil rights cases, especially in some of the prisoner cases, part of the hard discussion is making sure that on the one hand, you're recognizing that these are people who may very legitimately feel that they've been wronged. They may have been wronged, but trying to explain to them the process and the legal requirements and what they would have to prove, and things like the caps in Title VII cases, and the fact that the law gives a great deal of deference to correctional officers and decisions that they make in keeping order within prisons, and all of these things that as lawyers we understand, and we understand that as part of hopefully trying to make sure the overall system is fair. But to an individual who's had something very wrong happen to them, they might not understand the litigation risk of, well, technically maybe this case shouldn't be in federal court, it should be in state court, or there's risk here because the doctor gave you some treatment, and the standard for a deliberate indifference case is high in terms of what you would have to prove. And I understand you were in pain for a period of time, but here's what the law is. So hopefully in having that hard conversation, you're being realistic, but also coming at it from a place of acknowledging that you're probably talking to somebody who was wronged or hurt or suffered something that might not be contrary to law, but was still very upsetting to that person.
Yeah, I would I agree with my colleagues, and I would add, one of the things you're going to encounter in terms of the emotions, what you asked, Laura, is that, people feel wronged. They feel the system has let them down. There's this high degree of mistrust. They believe that the odds are, everybody is against them. They're hurt. They're upset. I think it's important, as well as all of the things my colleagues mentioned, is to, allow the client to vent. Allow the client to get out whatever emotions they have, because that's part of their needs and interests, right? Their needs and interests they want to feel heard, they want to feel respected, they want to believe they're being treated fairly, And part of the job of the Settlement Assistance Council is to build that trust with the client and make them feel heard and make them feel like they have someone in their corner who's going to advocate for them, but also understands them on a deeper level besides just exchanging numbers or hashing out, the legal difficulties in the case. So I'd say, allow them to vent. We certainly, in the settlement conference, allow people to vent and give them their time to tell us their story and allow us to empathize with them so that they also have a feeling that the judge has heard them and understands where they're coming from.
And one further thing I would say is just folks have to understand that I think a lot of people have the idea that you come to court and if you were treated unfairly, there's a remedy for you. And unfortunately, that's, as Judge Wood was saying, that's not always the case. Fairness, there's a disconnect between fairness and a legal remedy sometimes, especially for the people who either pretrial detainees or prisoners. There are a lot of things that a lot of hoops they had to jump through to win a case, and something very bad could happen to them, but there could be no remedy. And one final thing I would say is that they also should be made aware of that there's one outcome to a case going forward. Very few of them go to trial in our courthouse, under 2%, and very few pro se plaintiffs win their case. And if they lose, in many instances, they might be called upon to pay some cost. And I think a lot of people aren't aware of that. A lot of pro se folks aren't aware that maybe it's $3,000, $4,000, a couple of thousand, maybe it's higher. Sometimes nowadays it's much higher that the defendants will seek. But they need to know that too, that they may think they're getting a very low offer, but the worst case scenario is not zero. It might be paying whoever did you wrong. And they need to hear that from someone who's on their side. It's best to hear it from someone who's on their side first.
Excellent. Well, let's say that the parties have complied with your standing orders. They've exchanged letters. You've seen the letters. Is there anything in your practice that you do from that stage until you meet in person for a settlement conference?
So I get the parties on the phone, the lawyers only, and I talk to them about the letters. I ask them questions. I ask them to tell me if they are still optimistic about proceeding to a settlement conference based on what they've read. I ask them if there's flexibility and room to move in their numbers. So those are all signals to me as to, are they really interested in a settlement conference, or are they just, walking in, so let's see what happens, and, no big deal if we don't settle. I try to make it a more serious event so that there's an expectation that we'll settle. And, if they don't give me those signals, then maybe it's not the right time for a settlement conference. And I think what I also do to talk to the lawyers on the phone is I ask them, is there anything you'd like to tell me privately prior to the conference? And, I ask them to call me back right after that call and tell it to me privately. And a lot of settlement assistance counsel for our present purposes do. And they give me pieces of information that is helpful, such as, Judge, I'm having some trouble working with my client. Here are the issues. You're going to hear these things during the conference. I just want to let you know that I might need your help in getting over some of these issues. And those are things I appreciate when lawyers are able to reach out to the mediator and give pieces of intelligence that will allow us to structure the conference in the way that fits the situation. So the pre-settlement conference phone call is something I do for those reasons.
Judge Wood or Judge Cummings, do you do those pre-settlement conference phone calls, or do you receive them if someone just wants to call up before the meeting to talk about the settlement?
Well, one thing I do, I always insist that there's a written offer and a written demand, and sometimes plaintiffs are reluctant to give that for some reason, and a written offer so you could see where everyone is. And if it appears that the gap is too large, I will have a status hearing and perhaps have calls, because I just want to make sure that there's not something I'm not seeing, as Judge Harjani was indicating. Sometimes there's more to it than meets the eye, but I don't want to waste anyone's time. And I also don't want, and I saw this the other day, someone was like, well, I just want you to educate the other side, and then maybe sometime later we'll actually have a settlement. Well, I'm not really that I want to work with people that actually want to try and get something done. And maybe it doesn't happen, maybe it does, but I'm not in the business of trying to educate someone as to why they don't have a case when the parties are way far apart. So yes, there is some intervention. I would call it an intervention before the conference takes place, if it looks like it's not going to be something that has a reasonable chance of success.
So I guess in response to the question, normally, so the majority of the cases I have for settlement conference, I would refer to the magistrate judge. If I'm going to handle the settlement conference myself, it's usually because I've already made a determination that it's a particular situation where it makes sense for me to do it as the person who's most familiar with the course of the litigation and who's been involved. And so normally some of the early feeling out has already been done in that situation, where I know that I'm ready to talk to the parties. And that's the reason why I'm staying involved and keeping the settlement conference, because I've seen if it's a pro se person, I've seen them a couple of times. There's been a couple of amended complaints. I feel like there's a particular rapport, and so I've already made that determination when I assign the settlement assistance counsel, and we're ready to have a conversation. So I think because of that, I'm probably less likely to do a pre-call. I apologize for my voice. I actually just did a sentencing for most of the afternoon, and I've talked myself a bit hoarse, apparently. So I apologize for the state of my voice, and if you see me reaching for a drink from time to time, it's because I was talking for a couple of hours in a lengthy sentencing. But yeah, so I think my procedure along those lines is probably a little different, just because of the types of cases that I would keep for my own settlement conferences, versus where I think there's a real need to have that additional legwork of the side conversations with counsel and client. Those are the cases I'd probably be more likely to refer to the magistrate judge, because frankly, I think the lawyers are often going to be more frank with a different third-party neutral who's not going to be resolving the factual issues of the case. So I don't want the settlement assistance counsel to come in and then feel awkward because now they're sort of in front of the trial judge, but they're not really representing the person for a trial. It can get weird. So for me, it's usually that I've already made that determination that this is one where I just need to sit down with the parties and we can try to find a way to wrap this up without protracted litigation.
All right, well, let's move now to the conference itself. And before we talk more broadly, can we just focus for a little bit on the settlement conferences that involve people who are presently in custody? How has that been working in your experience? Like logistically, given how, any tips? What's your view?
So traditionally, people in custody generally would, in non-COVID times, would appear via video in our courtrooms. And the attorney would be present in our courtroom, and then the other side would be in a separate room if we're doing private caucus sessions. Since this, we're in the COVID world, everybody's on video. So I guess from the, the incarcerated person's perspective, things haven't changed that much for them, but it's certainly changed for everybody else. So in general, I think the answer to your question is, it probably hasn't changed much for incarcerated individuals because they were on video anyway prior to the COVID pandemic.
And sometimes it depends on what institution the person's in. I've had some conferences where the person has only been able to connect, the plaintiff has only been able to connect by phone. And that is not quite as good because I think oftentimes we as the judges, it's helpful for us to talk directly, and even for us, I guess, to build up some rapport with the parties. And it's a little bit more difficult just by phone. But that's been one change, and I think it's also probably more difficult for the SAP attorney as well, because there tends to be more logistical problems just connecting with your clients who are in institutions now that COVID is going on than there were before, even more so than there were before. So it probably would make your job more difficult as well.
Okay. Well, let's then talk more generally. You were in a settlement conference. You've exchanged the letters. As counsel for the pro se except for today client, you might have put together a really compelling story about how the trial is going to go, but everyone realizes that this is a limited purpose representation. And what have you found in terms of the other side's lawyers saying, yes, that's all very kind, but we all know you're not going to be here? That threat of seeing it through. We have a question from one of our viewers today wanting to know about how does that play out given the scope of the limited representation?
Well, I guess I would say, I mean, if you put together a nice presentation, at least as far as how I'm assessing the case with the defendant, I will point to your presentation and treat that as if that case could at least potentially be made going forward, even acknowledging that the SAP attorney might be here today and gone tomorrow, because they could agree to represent the person, or perhaps Judge Wood or another district judge could appoint counsel for the person, and at some point down the line, if they've actually got something to work with. So it probably does factor into the defendant's mind, but as in terms of how I deal with them, if it looks like there's something there, I will treat it as though that case could be presented and work with them that way. That's why it's very important that you put together a good presentation for your clients.
I agree. I think if SAP counsel tells me that if this case doesn't settle, they are interested in keeping the case and asking to do it pro bono, I will convey that to the defendants, because I think that's a piece of information they should know. Now, of course, you can't really bluff. You do that too often and you don't take the case, people are going to know. So you should at least be considering on a good faith basis keeping the case if it doesn't settle. But I do convey that information. And the other factor, as Judge Cummings mentioned, is if the case looks like there is a real issue here, the district judge could appoint counsel. I may email the district judge and say, hey, I recommend that counsel get appointed. It looks like there's something here. And he or she could really use the help and is unable to do it themselves going forward. So that's a risk I think that the defendant takes if they simply assume that an SAP counsel is, just a momentary glimpse in time, if you will. And, like I said, I think I convey the information if it's passed on to me, because I think that does have some degree of effect on how a defendant thinks of the case.
I would also say that as settlement assistance counsel, you can, certainly if I don't have the case for the settlement conference, I have had counsel, even when the settlement process is done with the magistrate judge, actually asked to come to the next status hearing in front of me and will say, I can't keep this case long term, but I think it might be worth having pro bono counsel or something. It's unusual, but you can signal that, and even if you're not willing to keep the case as a pro bono assignment, and there are a variety of reasons why that might be, that you can signal that in a way, as Judge Harjani was saying, to get pro bono counsel appointed for the duration of the litigation. The other thing, when I'm deciding which cases I think are good fits for the program, I'm also looking at the defendants, to the represented side, to make sure that they're also going to approach the process in good faith, and that it's not just they're going in the settlement because they're going to try to, sort of use their leverage and their advantages in terms of having, lawyers and familiarity with the process, or this sort of leverage that Judge Harjani was saying of they're going to be in the case long term, but people who actually really want to settle the case. And I find that most often the defendants and their counsels actually welcome the opportunity to have a lawyer on the other side of the case to discuss the real litigation risks and to see if the case can settle, because for many lawyers, it's very frustrating to try to have those settlement discussions with somebody who's unrepresented, and they're actually not all that interested in trying to litigate against a pro se if there's a way to avoid it. Most lawyers on the defense side, frankly, I think they would almost prefer, if there's any exposure for their client, to try to reach an early settlement, because they know that it can be frustrating to litigate with a pro se. And so if they can sit down, the person has a lawyer, now we can talk about the actual litigation risks and the causes of action, the sort of conversations that they feel they can't have with an unrepresented person, they're going to try to take advantage of that. So I certainly, I know Judge Cummings and Judge Harjani see a lot more of the cases than I do, but in the settlement conferences that I've had and in talking to the defendants, usually they want to take advantage of the fact that now we have a window where we can talk to a lawyer, and we might not be able to have an effective conversation if the person is litigating on their own.
Yes, and I can tell you from our perspective.
Oh, sorry.
I can say from our perspective, I love having the SAP counsel. One of the more challenging things for us is to have a pro se plaintiff in a settlement conference, because it's better to have an attorney there representing them for any number of reasons. And so I just want to thank everyone who's considering participating in this and who has participated. We really appreciate your service. The judges do, and Judge Wood is right. For the defense counsel, it's much easier to have a lawyer that you can talk to in legal language about how weak the case is, as opposed to trying to convey that to someone who's not going to trust you inherently and probably is not going to believe what you're saying.
Just my own experience, I've done a bunch of these, and in every single one, the lawyer on the other side has expressed to me at some point, they're, okay, like somebody I can talk to. We speak the same language here. Even in the situations that didn't settle, there's a feeling like, okay, here we go, I can talk to you. And I know that sometimes there's a feeling of concern, like I am in a firm and we typically are a defense side, and I feel a little uncomfortable being on a plaintiff side in an employment case. What about my corporate clients who don't really like the idea of all of these plaintiff cases? But if that's a concern of yours, please know the defendant parties on the other side are so appreciative of you helping this process that oftentimes that can be something you can talk to internally at your firm about why this is actually good, even if you're typically on the defense side of your cases. All right, so what kind of conduct do you see at a mediation that's helpful when parties are representing pro se parties? What do the lawyers do that you've seen and thought, yeah, that's pretty great. That was a good skill, or that's a good style that was helpful?
I can start. I think there are two things that I sort of look for with SAP counsel. I look for sort of the lawyer's mannerisms and the way they're talking to their client. And that tells me whether or not they've built up a good relationship. Are they able to talk informally? Can they joke around a little bit? Do they seem to have some degree of connection where they've spent time together prior to the conference? And of course, that's a little bit harder now in the COVID era, but pre-COVID, hopefully post-COVID, that will come back. And the lawyer will demonstrate they have a good relationship. That shows me trust. That shows me they've talked. They've gotten to know each other. The client holds the lawyer with some degree of credibility. And I think the other thing I look for that I really appreciate is a lawyer who sort of gets that balance between advocating and realizing the risk in the case. There's a spectrum between just falling on the sword, mentally thinking this case has no value and trying to squeeze whatever you can get, and going the other way and saying, we're going to crush the opponents. They have no case. The plaintiff's case here is amazing. There's a middle ground between that, obviously, and you can balance those two concepts, which is advocating for your client, but also being frank about the challenges in the case. I think that gets the best balance, and that demonstrates to me that it is the most helpful to the mediator in a conference.
And I agree with all that. And another thing I would say is, if the judge is explaining to you a possible approach or making suggestions to you, you don't have to listen to the judge, but things, in my experience, tend to work out better when you do, because especially if you're in an area of law you're not really familiar with, or you're dealing with another sort of litigant like a county or the state that you're not really familiar with dealing with in a litigation context. We know things about how they approach matters, and if you're getting some advice, you might be well counseled to take it seriously. You don't have to do it, but I've seen the counsel be more successful when they consider the court's advice in these conferences.
I think I agree with, sorry, go ahead, Judge Wood.
I was just going to say, I think it's always good to see that the lawyer has a good idea of what's really important to the client. Not so much, in the prisoner cases, it often is a matter of compensation because that's really what the issue is. But I think our second most common category of cases that go through settlement assistance are pro se employment cases and issues like that. And sometimes things come up where you have a plaintiff who wants an apology, or do they want their job back, or do they want a letter of recommendation? Is this a matter of pride for them? Is this, sometimes you can tell whether the assigned counsel has really had a conversation and listened to the client about what's really motivating them. And that's always a good sign, I think, if you can, sort of see that they've really had a conversation, and it's not just, here, I'm going to tell you, here's our opening offer, and here's how we're going to approach it, but there's actually been an effort to kind of understand what is it that's going to drive whether or not my client actually ends up settling the case. And a lot of times there's something else going on there beyond just, I want to get at least $50,000. Some of the things that they are interested in are not things that you can get relief for in court. Some of them are things that you actually can. I have had settlements where a letter of an apology was part of it, or an agreement that somebody's going to get either a neutral reference or agreements that certain information isn't going to be disclosed publicly or other things. And sort of being willing to explore those options with your client, to know what's important to them, to know whether it's something that you can actually help them with, and to kind of communicate that. I think that's very important and always a good sign that they've had those conversations. The other thing that I sort of would look for in trying to make sure there's an effective attorney-client relationship is that the lawyer's not just talking down to the pro se. I know a lot of times the pro ses, they sometimes feel that the lawyers are talking at one level and kind of leaving them out. I think it's important for the settlement assistance attorney, one, to set realistic expectations for the client of, look, there are going to be times in the settlement conference where you have to let me talk. And I'm going to talk to the lawyer, and I'm going to talk to the judge, and here's what it means when I say this or that, so that the client doesn't feel that they're sort of being ganged up on by the lawyers in a room who are speaking a foreign language that they don't understand. So if you've had that discussion with your clients so they understand what's going to happen, and they feel like, yeah, when you are in there speaking that foreign language, you really are doing it on their behalf because you have the credibility and trust that Judge Harjani spoke about, that's when you know that you're being an effective advocate in that setting.
Yeah. I was going to add, along with what Judge Cummings and Judge Wood said, there are two things I think that are really helpful and that we look for, and I would advise any settlement assistance counsel. One is don't come in with a bottom line. Don't even talk about a bottom line with your client because your bottom line might be way off. We settle a lot of cases that are pro se in employment and with the IDOC, the Department of Corrections. So we have a sense of what range a case can settle in or should settle in, and you might be completely off because you don't practice in that area. So, coming to a bottom line, don't worry, we won't take less than this much. That can cause a problem later on if you are way off target as to what that is. And I just said, second thing, along with what Judge Wood said, I completely agree. I think if you are settlement assistance counsel and you find yourself just not having that time to build that relationship with the client, think about bringing a younger lawyer with you in. Think about bringing an associate or someone else a few years out of law school. I can tell you that we really enjoy seeing young lawyers in our courtroom. It gives them great experience. I always make sure to talk to them. I make sure to give them opportunity to speak. We particularly like seeing diverse lawyers in our courtroom and women lawyers and getting to know them. And so I would encourage you to, I see a lot of lawyers come themselves, and that's fine, but they're experienced, they've been practicing for 30 years. And I was thinking to myself, why isn't there a younger lawyer in the room with you? Now, if you are a solo practitioner, that's fine, but a lot of participants are not. And so I would encourage you to do that because I often find that the younger lawyer has a time to build that relationship with the client. And sometimes that relationship between the younger lawyer and the client really makes a difference in the case.
Can I say, I think that's a great suggestion. And one, it's great because experience in settlement conferences is usually the last type of experience that a young lawyer gets at a big firm. And it's difficult to learn how to negotiate. And so I think exposing younger associates, if you're at a big firm or a mid-sized firm and you have associates who need to get that kind of experience, it's a great opportunity for them to learn how to do it. And the other thing is, I will say, is sometimes the pro se feels like they get a little confidence in you when they see that they have a legal team, because they look at the other side, and the other side may be a firm and they've got a legal team. And if you're like, this is me and I have my associate, and we're going through your file and doing research on your theories, sometimes it does sort of give it builds that little extra bit of credibility that you may have with the pro se, where they feel like, yeah, it's not that you're pushing my work onto a junior person, it's that now I have a legal team, and they're gonna work for me the same way that the team on the other side is working.
All right, now it's sort of a delicate issue that can arise in these cases where and I've personally experienced this myself, where I want the judge to convince my person, come on, this is a good deal, take this deal. But I have an ethical obligation. I'm representing the client. The client controls the deal. And I can't just pull the judge aside in the hall and say, if you say this thing, it's going to make a difference. So I don't know if I just confessed something, but I don't think I'm the only one who has this feeling where if you just really can see that it really would be in the client's interest if they take the deal or move from their position. So when you see lawyers in that kind of that struggle, what have you seen effective? Have you seen anything effective in kind of moving the client where you can tell the lawyer wants to move the client, but is maybe having a little challenge in doing that while still maintaining the role as advocate of the client?
Yeah.
Well, I would say one thing, it might be a little counterintuitive, but I think it's very important, which is to empower the client. I mean, and to emphasize to your client that it's his or her choice whether they want to settle the case. And you're going to do your best to get the defendant to come up as high as possible, and you'll point out the pluses and minuses once that point is reached. And again, with Judge Harjani, not having a rigid bottom line or something we won't take and we won't settle if we don't get this is very important, because you want to get to the end of the day, negotiate, and then let the client know you're going to tell them the pros and cons of taking it, but the choice is theirs. And sometimes that feeling that they're, that they really, and they do have the power, they're the ones to say yes or no, actually opens them to listening to your reasoning as to why they should accept something or not, or why it's a good idea. It opens them up more to listening to you when they feel it's their choice. And so that's one thing I would recommend and suggest to you.
Yeah, I've had, different lawyers do it differently. I've had lawyers, catch me in the hallway. They'll know I'm going to the other room, and they'll tell their client they're going to the bathroom. And they'll come on the hallway and they go, Judge, can I chat with you for a second? I really think, my client should take this. I'm having a hard time getting her there. It's her choice, but I just want to let you know, what I'm trying to accomplish today. It's totally fine. I'm always open to it. I think, if you can sort of break away, and that's harder to do now on Zoom because it's so obvious that you are engaging in a conversation outside your client's presence. And if you don't want to do that, some lawyers give signals, like, Judge, we're having a debate among ourselves as to the proper range here, and we really would appreciate if you weigh in. I'm advocating for my client, but I do think that this range is probably where we'll end up. And I think my client thinks that range is higher. These are all in private sessions, right? They're not happening in the presence of the other side. So you can be more frank. You can be more honest. And, if it makes you feel better, just say, Judge, can we keep something between the three of us? And of course, I would say yes. And then you have that, that conversation, delicately pointing out there's a debate between the two of you as to the approach we should take. So I find that to be very helpful. And then I'm able to tailor the strategy as a result of that piece of information.
Okay, we have a couple of questions, so I want to make sure to save some time to ask them. But my last topic before we move on to the questions, let's assume you have a deal. What are your thoughts about putting something on the record at the end, or versus people going home and just writing it up? And then what is your experience if there are any disagreements that arise after people think they have a deal, but then go back to their offices and, I didn't realize there's indemnification, or you want it in 30 days, like those types of topics. So I'd love to hear on both of those.
I guess I can go first. I imagine the answers can be same for many of us. One is I always go on the record if there's a settlement, and I always place the material terms in the settlement on the record, and I always make sure that it's voluntary, knowing, and binding. And so I ask all the right questions to make sure of that. And then on the second question, I always tell the parties, I'm always available to help you. You know, if you really run into a jam, don't feel like you're on your own. Call my courtroom deputy, set this for a status or a call, and tell me what's happening, and I'll help you through the process. The last thing we want is a settlement to blow up, right? We've worked really hard. The district judge sees the entry. He or she knows this is almost there and off the docket. So we're all, you know, right at the finish line. It does nobody any good, including the court, for something to blow up. So we are, you know, the message is, I always say, is we're here to help. And, you know, whether it's you or the client that's, you know, having some difficulty, just give us a call.
Right.
Yes, and I'll tell you now, with the Zoom and with the Teams, we use Teams, no Zoom. Yeah, what I do is I have everyone come back and get in the same room. We have a record function, and I'll have one of the lawyers recite the terms. Everyone else is listening. The other lawyers can chime in. The clients can ask questions. Everyone's on the screen, and then I'll turn to the plaintiff and say, Mr. or Mrs. such and such, do you agree to this? Yes. And then to the defense representative, yes. It's recorded, and I can tell you I have had only 2 inquiries after settlement conferences. Once the recording was sent, there's been no issues after that. I mean, I found that to be even more effective than actually being on the record in court, because you have the person, you have their video of them saying yes to a deal. It's tough to get out of. I mean, it's tough to say I didn't say that. That's not me, you know. So I found it works very well now.
Great. So back to the structure, I have a question about this, and it's an important point I should have covered. What are your thoughts about having like opening statements at the start of the settlement conference? Do you like to have the parties make a presentation to each other? How do you organize the early phase?
I would say no, typically, unless someone really wants to say something. I've had a case where it was actually a police misconduct case where someone died and the person's mother wanted to make a statement, and it ended up working out. But usually I don't have any opening statements. I'll say some things, and if there are questions, but then we go to sessions, because it can change the vibe of the settlement conference to have like a opening argument, and you know, it's like argument, it's like litigation, and it's not like settlement.
Same answer.
Yeah, I would agree.
Okay. All right, so let me look at my questions here. What have you seen in the prisoner cases? Judge Wood, you mentioned some non-monetary terms that you see sometimes in employment cases. What are some non-monetary terms you might see, have you seen in deals in prisoner cases, if you feel comfortable answering that?
Non-monetary terms, you know, it's interesting because you mentioned the value of putting things on the record, which I think is absolutely incredibly important. I think in terms of non-monetary terms, it's often the things that the IDOC or Wexford routinely includes that they consider to be non-negotiable, that if it's a prisoner and it's their first case, they might not be aware of, that might trip things up. The scope of the release is something that's, I think, very basic for lawyers, but it might be difficult for a prisoner to understand, particularly if they have multiple cases, you know, maybe even cases at different facilities, cases involving different officers, different time periods with the same officers, making sure that they understand the scope of the release and what they're giving up, because sometimes they're surprised when they see a term in there indicating that they are releasing all claims, you know, from the beginning of time up until when they sign their settlement agreement. So those kinds of things, I think, are important in the prisoner cases. You know, a lot of times in prisoner cases, especially if it's a medical case, or even in some of the conditions cases, there are issues of injunctive release or relief or policy changes that a prisoner might want. So I've had cases where a prisoner wants to have something in the manual for the prison or the county jail changed. And actually, I've had some who have been successful in getting changes to policy manuals. So don't assume that you can't do some of those things. I actually had a pro se on his own get a change to a policy manual with respect to reading materials that prisoners were allowed to have in their cells. So that's something, sometimes things in the nature of injunctive relief or changes to policy manuals. You know, often in medical cases, there's an issue of, you know, requesting specific types of care. That yes, they want money, but they also want, you know, for example, Wexford to be required to refer them to a specialist to look at their ear and different things like that. And these are things that sometimes you can actually work with. And then some things are just not possible for policy reasons. But you shouldn't assume that these other types of things are completely off the table.
Okay, sorry. Okay, another question I have relates to prisoners. Is it possible to do, this should be yes or no, I'm guessing, it's possible to do settlements of cases where the prisoner has not fully exhausted their administrative processes in the prison? Do those ever settle, or is that not possible?
Well, sometimes what happens is the defendant claims that they haven't done that, and they say they're going to move to dismiss or have some other sort of hearing to get the case dismissed, and so that's how it comes to you. They don't. It's not always agreed that there's been exhaustion, but the plaintiff typically says that they're representing that they've exhausted their remedies. I haven't seen one where the plaintiff comes in and admits that they haven't exhausted, because that's kind of a fatal sort of situation for them.
Okay.
Yeah.
Another question I have is, do you know of any good sources for someone who's new to this area to find sort of kind of typical ranges of settlements? I think, Judge Harjani, you mentioned that people might not, practicing in this area, might not realize that something isn't only a, you know, $2,000 case or whatever. Have you found any good sources for lawyers to kind of get a sense of ranges?
That's hard. You know, for settlement, I think that's a little difficult. I'd say one of the best sources actually is Cunyon Gordon, who you met,
Yes.
who is your contact if you join the program. She's been around a long time and she's seen a lot of these. So I know a lot of SAP lawyers talk to her about their situations and get some advice from her. So that'd be a good source besides, you know, the judge during the conference.
Another question about the letters. I'm assuming that when we were talking about letters before, these are letters to be exchanged between the parties. Do you ever do letters just to you directly where you're kind of expecting, say, more frankness about the weaknesses and the risks? And if not, are you looking for the letters between the parties to have some acknowledgement of the weaknesses of their case?
Well, very quickly for me, I expect that the parties' letters will reflect that they don't have 100% chance of success, meaning that they don't come in with a maximum relief or a zero amount on from the defense offer. So that would involve some recognition that perhaps there's risk, and certainly when a defendant responds, there's an opportunity for them to acknowledge some points by the plaintiff as well.
Yeah, I've done confidential. Oh, go ahead.
Also, I would say I'm receptive to a lawyer's request on that. So I may not necessarily bring it up myself, but if a lawyer tells me, Judge, I'd like to tell you some things in private about what we're thinking as to a range here, can I send you a letter to your settlement email box? I'll always say yes. And then the other side might want to do the same thing as well. So I think if that is something you're thinking about, just ask us.
Yeah, and I have adopted it as a procedure in some circumstances of just asking for confidential letters. You know, and again, it partially depends on what stage the case is in. And again, oftentimes I have the benefit of, you know, if it's gotten past the motion to dismiss, I've actually gone through that process with the parties. And if it's a pro se who has survived the motion to dismiss, I have a pretty good idea again of kind of what their mindset is and what the issues are already and the legal hurdles that they're going to have to clear. So sometimes I do find it more helpful in some cases to just get a confidential correspondence from the lawyers with the hopes that they'll be a little more candid about the litigation risk. Again, sometimes I assume that they won't be that candid if I'm the judge that's going to be handling it all the way through. And in those cases, I'd be sure to say, you know, I'm going to refer you to the magistrate judge so you can be candid about what you want. So sometimes I think I can ask them for a confidential letter that candidly discusses litigation risk. But I also want them to feel comfortable doing that and that they're not somehow betraying their client in sharing that information with me. And if that is the case, or if I sense that's the case, you know, sometimes I've had pro ses ask why I'm referring a case to the magistrate judge. And it's not necessarily that they particularly like me, but oftentimes they think it's going to be faster. It's like, I've got a judge in front of me. Why do I have to go to a second judge and then potentially back to this other judge? And I'll say, look, it's part of this is you're going to go to somebody who you can be frank and honest with, and you don't have to worry about how that's going to impact the other side of things, the litigation side of things. And a lot of times the pro ses will understand that and appreciate that.
All right. Well, I'm sad to say that we're out of time because we probably have 40 more minutes of good questions in the queue. And so I would encourage anyone who has a question that we haven't gotten to yet to please bug Kanyan Gordon, who I know, reading these questions, I know that she has good answers on all of them. And if she doesn't know off the top of her head, she'll know where to find them. So please make sure to reach out to Kanyan. And with that, I'd like to thank our judges for their time today and their insights. It was very, very helpful. Thank you. And I think Kanyan's going to be coming back in to wrap us up for the evening. But thank you all for attending. And I look forward to seeing more settlement assistance lawyers now that we have a whole new crop.
Yeah.
Kanyan, are you here?
Thank you very much.
Thank you.
Yeah, thank you. Thank you for having me.
For everyone participating, and we look forward to seeing you in the courtroom with us.
Yeah, absolutely. Thank you.
This was terrific. Thank you very much. I want to thank again Judge Paul Meyer, Chief Judge of the District Court for the Northern District of Illinois. I want to thank District Judge Andrea Wood, Magistrate Judge Sunil Harjani, Magistrate Judge Jeffrey Cummings. I want to thank the moderator, Laura McNally. I want to thank Allison Margulies and Ali Schaller for their participation. And I also want, as a point of personal privilege, to thank Margot Klein of the Seventh Circuit Bar Association and Lisa Jackson of the Federal Bar Association for all the tremendous help that they gave us. I had a question earlier that talked about the district court and having the district court schedule be stayed in the case of appointment of counsel. Many of the judges, I'd say most of the judges, do stay discovery while the parties are considering settlement, because otherwise it's awkward to have the client dealing for settlement through the Settlement Assistance Council and dealing for discovery directly with the opposition, so that to avoid that awkwardness, most of the judges do stay discovery during the pendency of the conversations around settlement. I will answer any other questions if you contact me at my email. And again, thank you. I thought this was very informative. Every time we do this, I learned something new. And I hope you did too. And I look forward to having you all volunteer. So good night and thank you very much.